All right, that should be the YouTube and Floatplane subscribers, the patrons, the supporters, the insiders, and then we're going to start the one for Twitch in a second here. But yeah, let's see. Can I get a mic check? Mic check. One, two, three. No, this is too small. Make this bigger. Now I can see the messages. Hey, there we go. Okay. Check the actual dashboard. Is this running now? Yes, this is running now. Yay. And we can. Why do I not have a. There we go. Okay. It updated. And then Twitch. Twitch connecting. Twitch connected. There we go. Hello, everyone. Welcome. It's not May 4th, so I hope the 4th was with you yesterday, but now it's Cinco de Mayo. No longer Cinco de Cuatro, Arrested Development fans. How are we, everyone? Hello, Kaylee, my most loyal fan. Hello, Tactical, probably my second most loyal fan. Hello, Emzine. Thank you for your 44th month of subscription. UN Tactical, 64 months. Leaky Glock, hello. So I don't know. I trust my staff and friends and supporters, and so many of you said you should check this out. This Hughes v. Garcia case out of the Fifth Circuit Court of Appeals, Southern District of Texas. So I thought that we would check that out today. What do you think? I do. Let me see if I can get it ready here. I do have the reaction cam. Um, hmm. It's maybe I have to adjust the reaction cam. Hang on. Let's while we're all pouring on. That is not good at all. It reset when I turned on the thing. Can I restore the start of the state that I need? This should be with this file maybe. Restore, and that would be a no. What did I do? Oh boy. Fade to black. That's what I did. Okay. Let's not do that again. Let's see. We need a little more gain on this one. Okay. Cool. And maybe a little more blue. Are we headed towards yellow? We're headed towards yellow because I'm compensating towards blue. We're compensating towards yellow. There we go. Maybe that's a little too much. All right. And then we've got back to 1 here, which is now reset to the wrong gain again. Let's get you back on. 18 dB sounds good. All right. That's why you turn the camera software on before Leonard After Dark. After Dark was awesome. I especially loved the there was like a more mature. It wasn't adult oriented, but it was like a more mature one, and I liked that one too. So hello everyone. Hello Coral. Good morning, good afternoon, good evening. I guess not yet good night. We use good night to say goodbye, so I'm not saying good night. Have a good night. Hencalv. Hello. So, without further ado, I heard there was a qualified immunity story that you might be interested in. It is called Hughes versus Garcia. Austin Thompson Hughes versus Michael Garcia and Joshua Few. And if I have my facts correct, those are the officers who pulled, or not pulled over, but who arrested Mr. Hughes, who was acting as a good Samaritan. Let's let the Fifth Circuit tell the story. It will tell itself. It will tell itself. The story will tell itself. This is Andrew Oldham, circuit judge, writing. For those who worry that qualified immunity can be invoked under absurd circumstances, buckle up. Austin Thompson Hughes is a good Samaritan. After 2:30 a.m., Hughes called 911 to report a pickup truck swerving violently across a 4-lane highway in Houston. While Hughes was on the phone with emergency dispatchers, the drunk driver crashed. Still on the phone with Hughes, Still on the phone with 911, Hughes pulled behind the drunk driver and effectuated a citizen's arrest in accordance with Texas law. But when police officers arrived at the scene, they let the drunk driver go and then arrested Good Samaritan Hughes. Seriously. And for those who are listening and not watching, the court has put seriously in parentheses. This was not my editorial comment. Piling insanity on irrationality, the officers then charged Hughes with a felony for impersonating a peace officer. Hughes spent thousands of dollars defending against the frivolous criminal charges before the city of Houston dropped them. Then Hughes brought this Section 1983 civil rights lawsuit against the two officers who victimized him. The district court denied qualified immunity. We affirm. Obviously. Yeah, so that's just on its own. That's absurd. But also, pardon my bias, but also in line with my experience of the unpredictability of police officers. Let me qualify that. And let me bring my microphone over here a little bit. Um, my experience with police officers has been mixed, and it's not that all officers are bad or defund the police. Never, no, not something like that. Instead, it's more like they're a legalized gang, and once you're in the police, you'd better go with the gang's rules or else. And I'm not sure where that could come from other than the original intent of the police. We used to have state peace officers. They used to be called peace officers or constables. We didn't have a local police force in the same way that we do now until the Civil War. And then after the Civil War, there was a period of time in the South where there were freed slaves, but there were people who didn't want them to be free. And then they would form these gangs that would find ways to charge or harass or whatever freed slaves, get them into the court system or the prison system or whatever, where they could then be made to do not prison labor. We don't call it slave labor; it's prison labor. It's prison labor, thus solving the problem of having freed the slaves. So I'm not super happy when police officers continue to behave like that. So in this case, I don't know the motivations behind two police officers arresting the person trying to help and letting the perpetrator go. So I'm really interested in what what the court is going to have to say. And that's the framing, that's where I'm coming from with it as both a person, an American citizen who has dealt with American police officers, but also as a lawyer who has dealt with American police officers. And it's not that every one of them is a bad police officer or even the majority. It's that the public needs to have 100% confidence that when they interact with the police, they're going to have a positive interaction. Otherwise, even one bad officer, this one remarkable case, will deter people from interacting with police officers. The same way it deters people from interacting with the legal system, the same way it deters people from interacting with lawyers when lawyers do it. Same thing then with when doctors do it. And how do we react to untrained lawyers and untrained doctors or lawyers or doctors with power trips? There's a disciplinary body, and unfortunately, that disciplinary body for the police seems to have failed. It's one of those we investigated our own and found no wrongdoing. Um, so there's something that has to be done there. More training, better funding, but better funding with audits on the backside. Yeah, better funding, but under the supervision of someone who knows what they're doing. Because the reports that I hear and read about from qualified from good sources are that the police get trained for 6 months and they get trained that it's us versus them, that we the citizenry are the enemy and the police must keep us in line, and were it not for the police, the citizenry would consume itself, would devour itself. And I don't think any of this is true. I think the peace officers need to be just as peaceful as the citizens they want peace from, while also being able to deal with citizens that are not peaceful, who are themselves breaking the social contract. So it's a complicated situation, and why you can't have people in a position of trust acting like this. So, long aside, let's begin. This case arises from a motion to dismiss, so we are taking the following well-pled facts as true. Now that's important. A motion to dismiss stage means that the court assumes the well-pled facts, facts that have passed the Federal Rule of Civil Procedure 8 pleading test for plausibility. These are plausible facts, not mere conclusions. And the judge is going to assume that those facts are true at a motion to dismiss stage. So we're at the beginning of the complaint. The complaint has been filed. It has been served on the defendant. The defendant has filed a motion to dismiss. We did not answer the complaint. We did not go through discovery. We are not at summary judgment. We are not at a jury trial. We are at the very beginning. So these officers still could prove something more. Maybe the court strips qualified immunity at this stage. Maybe they prove that they deserve it later, giving them the benefit of the doubt. But let's see what you think after we read what the judge has to say. On March 23rd, 2019, at approximately 2:37 a.m., Austin Thompson Hughes, himself a former police officer, was driving for Uber. I'm starting to see something that makes sense. So the victim is a former police officer, and the perpetrators themselves are police officers. Fill in the blanks. While driving, he saw a white GMC Sierra pickup truck swerving erratically on Interstate 610 in Houston. Suspecting the truck's driver was intoxicated, Hughes dialed 911 and followed the Sierra with his Jeep's flashers on. During the call, Hughes described the Sierra and his own vehicle and reported the truck swerving at high speed, hitting the concrete barriers on both sides of the highway, and finally coming to a stop. Hughes's two Uber passengers can be heard on the recording confirming Hughes's observations. Hughes stopped behind the Sierra. At some point during the episode, Hughes's 911 call was transferred to a Houston Medical 911 call taker. Hughes continued to report to the second 911 taker. This is a common and very frustrating thing with the 911 system in America. For example, in Pennsylvania, lived near the border, and I would call 911 for something and get New Jersey, even though I was in Pennsylvania, a half a mile on my side of the border. And then they get frustrated with you like you did something wrong. Not my fault. Please transfer me to the right person and do it as quickly as possible because, it's an emergency. But this whole dispatch center and then transferring around and crap is better than nothing. But aren't we doing better than nothing in 2024? Better than nothing? He told the call taker, "I need to get the driver out of the car because they're going to kill somebody." Hughes then exited his vehicle, observed that the driver was obviously intoxicated, and retrieved the driver's keys, license, which was sitting in the Sierra's center cup holder, and bottles of alcohol, which were, I guess, open in the car. A third-party caller corroborated many of these details to another 911 operator, including Hughes trying to get the drunk driver out of the car. When Hughes returned to his Jeep, still on the phone with 911, he saw the intoxicated driver exit the Sierra and attempt to flee towards the center of the interstate on foot. Hughes yelled at the driver to get back in his truck in an attempt to prevent him from being hit by oncoming traffic. The 911 operator disconnected the call, assuring Hughes emergency units were on their way. The drunk man continued to move into oncoming traffic on foot. Hughes felt the best and safest option would be to physically restrain him, so he retrieved handcuffs from his Jeep and used them to temporarily detain the DWI suspect. At no point did Hughes identify himself as a police officer. Finally, Hughes suggested his two Uber passengers request a new ride, which they did. When HPD officers Michael Garcia and Joshua Few, our defendants here, arrived on the scene 17 minutes after Hughes's initial 911 call, they re-handcuffed the drunk driver and asked Hughes to meet them at a nearby gas station so they could take his statement. To meet them at a nearby. Bleh. They re-handcuffed the drunk driver and asked Hughes to meet them at a nearby gas station so they could take his statement. At the gas station, Officer Garcia interviewed the drunk driver while Officer Few interviewed Hughes. Hughes recounted his observations of the pickup truck's erratic movements, the driver's multiple collisions with the median and concrete barrier, and his assessment of the driver's intoxication. Hughes also told Few that he used to be a police officer. When Garcia finished taking the drunk driver's statement, he asked Hughes for his Uber passenger's contact information. Hughes explained that Uber's privacy policies prevented him from accessing that information, but he later showed Garcia his Uber app, including the details of his most recent trip. Later, at Garcia's request, Hughes emailed Garcia screenshots of his Uber trip details. Inexplicably, the officers did not arrest the drunk driver. Few and Garcia then prepared an incident report. According to Hughes's complaint, the report recounted the drunk driver's statement to Garcia at the scene. So here's the drunk driver's statement. I was at a flea market with Jesse and his friends. Jesse said that we could go back to his place and that he lived on 59 South near downtown. I told Jesse that I lived on I-10, and he said that he would take me home later. I said okay because I had been drinking that night and had more than 7 beers. I was too drunk to drive, but I had a friend at the bar that could take me home. Jesse said let's go to his house, and he offered me a drive, so we went. Midway during the trip, I was not familiar with where I was at. I started to ask Jesse where he was taking me. I finally asked Jesse to just take me home, and he got mad. He asked if I had something going on with his wife. I told Jesse no. Jesse then asked me what I got going on with his wife. I was confused and asked what he meant. Jesse said he knows there's something going on. Jesse stopped my truck on the freeway and got out of it. He came to the passenger side and was trying to get me out of the car. I was confused at this point, only wanted to know what was going on. Jesse kept telling me I am fucked and how I was going to get deported. I was on the freeway, so I could not just get away from Jesse. Finally, Jesse told me to turn around and put my hands behind my back. When I did not do it fast enough, Jesse kneed my legs to force me to comply. I asked Jesse why he was doing this, and who gave him the right to do this. Jesse told me he was a police officer. Jesse then put me in handcuffs. My leg was hurting, making it hard for me to stand, and I had scratches on my wrists from him trying to handcuff me. The report, back to the real world, the report credited the drunk driver's version of events, despite the obvious fact that Hughes's name is not Jesse. Hughes and the drunk driver had never met. There is no evidence that Hughes accused the stranger of fooling around with Hughes's wife. Hughes never drove the drunk driver anywhere. Multiple independent witnesses and 911 callers, including Hughes's own recorded 911 call, and the Uber app screenshots confirm Hughes was not driving the white GMC Sierra. And there is no evidence of a flea market open in Houston at 2 a.m. Much less a flea market that doubles as a bar, where the drunk driver could drink more than 7 beers. But the report did indicate that Garcia conducted a field sobriety test on the drunk driver and that Garcia got 6 out of 6 clues suggesting intoxication under the horizontal gaze nystagmus test. Nystagmus. HGN test. Gee, why do people not trust police officers? Why? I can't imagine. No, this is solid police work here. This is exactly what we want out of peace officers. Let the drunk driver go and make up a story about the the Good Samaritan. This is exactly the kind of peace work we want. As to Hughes's statement, Few, remember defendant Few, reported Hughes told him about his Uber passengers, his decision to stop the drunk driver, and explained he had handcuffs in his Jeep because he was a police officer at one time. The report also included some details from the Uber screenshots Hughes provided, but the report misinterpreted the scheduled destination shown in the screenshots as Hughes's actual stopping point, ignoring the fact Hughes had obviously stopped on the freeway before reaching that destination. Despite the inconsistencies in the drunk driver's story, the Sierra driver's obvious intoxication, and the corroborating evidence for Hughes's statement, the report did not address the incident as a DWI investigation. Instead, it addressed an offense for impersonating an officer and identified Hughes as the suspect. The report thus credited the drunk driver's statement that Hughes told the drunk driver he was a police officer. Officer Few submitted the report. 2 days later, Garcia signed a probable cause affidavit based on that incident report. The affidavit asserted Hughes unlawfully, intentionally impersonated a public servant, namely a peace officer, with intent to induce the drunk driver to submit to his pretended official authority and to rely on his pretended official acts by stating he was a police officer. The affidavit included information gathered by both Garcia and Few during the investigation. The affidavit again recounted several details allegedly from Hughes's 911 call, but the affidavit omitted critical information like Hughes's play-by-play of the Sierra swerving erratically down the highway, his description of his own vehicle, and Hughes yelling at the drunk driver to get back in his car. Instead, the affidavit claims Hughes can be heard on the 911 call asking the drunk driver for his identification. According to Hughes, he never made that request. The drunk driver's license was in the cup holder of the Sierra, so Hughes simply retrieved it. The affidavit then provided a different version of the drunk driver's statement than the incident report offered. According to Hughes's complaint, the affidavit, which is, I believe, the police officer's affidavit, said, the probable cause affidavit, said the drunk driver told me that while he was being detained and handcuffed by Mr. Hughes, he asked Mr. Hughes if he was a police officer, and Mr. Hughes replied, "Yes, I am a police officer." The drunk driver stated that when he refused to turn around, Mr. Hughes struck him multiple times with knees to his legs. The drunk driver stated that he had been drinking at a flea market on Airline Drive. That doesn't exist. And met Mr. Hughes and his two female friends there. The drunk driver stated that they talked most of the night, and Mr. Hughes invited the drunk driver to his house to have some drinks. The drunk driver stated that Mr. Hughes offered to drive his white pickup truck, and the drunk driver agreed since he had been drinking. The drunk driver stated that Mr. Hughes told him he lived on the 59 freeway going to downtown. Mr. Hughes and the driver headed out, and two females drove Mr. Hughes' Jeep. I'm not sure how two females drive at one time. The drunk driver stated that mid-trip, he became uncomfortable with the situation, asked to be taken home. He stated that the argument began, and Mr. Hughes got upset and pulled the vehicle over on the freeway, and Mr. Hughes got out and began ordering him out of the vehicle, handcuffed him, and hit him in the legs, and he felt pain and wanted to pursue charges. The new details, like the previously undiscussed two female friends, who purportedly drove Hughes's Jeep to the scene on Interstate 610, appeared nowhere in the incident report and contradicted Hughes's statement. Moreover, Garcia reported that an Officer A. Walters assisted him in interviewing Hughes, but there is no other evidence Officer A. Walters had any involvement in this case at any time. The new version of the statement also omitted key facts suggesting the drunk driver's unreliability. For example, the affidavit made no mention of the drunk driver calling Hughes Jesse, or the apparent confusion about whether the drunk driver was drinking at a flea market or a bar. And perhaps most tellingly, the probable cause affidavit omitted that the officer's sole basis for believing Hughes committed a felony. The drunk driver's statement came from the ramblings of a man who flunked all 6 clues in the HGN intoxication test. Finally, as to Hughes's statement, the affidavit omitted any corroborating evidence supporting Hughes's account of the incident. For example, the affidavit omitted the third-party 911 call and the screenshots from Hughes's Uber app. Instead, the affidavit reported Hughes would not disclose his passenger's contact information. Despite these misstatements, omissions, and inconsistencies, Garcia submitted the probable cause affidavit to the district attorney's office, and then that's where it should have ended. But no, some idiot district attorney didn't investigate any further and went with the charges. The DA charged Hughes with felony impersonation of a public servant, and the 262nd Criminal District Court of Harris County issued a warrant for Hughes's arrest. Unbelievable. At about 3 a.m. on March 25th, officers Few and Garcia went to Hughes's home to arrest him. The record does not reveal, and judicial imagination cannot fathom, why the officers needed or wanted to execute this arrest warrant at 3 a.m. But Hughes, who was asleep with his wife at the time, answered the officers through the door. Few and Garcia asked to see the Uber app, insisting they needed to see his actual cell phone rather than the screenshots. He cracked open the door to give the cell phone to the officers. Instead, they grabbed his outstretched arm and pulled him out of his apartment into the hallway and handcuffed him. The record does not reveal, and again, judicial imagination cannot fathom, why officers needed to trick an undressed Hughes into extending his arm through the cracked door so they could forcibly arrest him in his pajamas. Few and Garcia allowed Hughes's wife to clothe him before taking him to the Harris County Joint Processing Center. Hughes was placed in the jail's general population for over 24 hours. You know they don't place police officers in general population, but they did this guy, like Alexei Navalny and I forgot his name. That's very sad. Sergey, Bill Browder's guy, Bill Browder's lawyer, Magnitsky. And I'm not saying that this is the Russians doing that's political dissidence, but this is police officers doing it to somebody they didn't like, another police officer who stepped on their turf, because remember, this is a legalized gang, and he stepped on their turf, so they put him in general population because they can't hurt him, but general population can, and then it's not their fault. Hughes was charged with a third-degree felony. Hughes was charged with third-degree felony impersonation of a peace officer under Texas Penal Code. The charge carried a minimum 2 years, maximum 10 years, and possible fine of $10,000. Hughes hired a defense attorney. 3 months later, the state of Texas requested that the criminal action be dismissed on the basis that no probable cause existed to believe the defendant committed a crime. So they did all that to him, and there was never any probable cause. The county judge dismissed the case the same day. Hughes sued various officials, the city of Houston, Harris County, all under 42 U.S.C. 1983. As relevant to this interlocutory appeal, so during litigation, we normally appeal after a case. This is during litigation. That's what interlocutory means. Hughes alleged Few and Garcia violated his 4th and 14th Amendment rights to be free from unlawful arrest and malicious prosecution by filing a false report and by knowingly standing by while the other officer did so. Few and Garcia moved to dismiss Hughes' complaint asserting qualified immunity. The district court denied both officers' motions. Few and Garcia timely appealed. Why would they appeal? Why do you think they'd want more attention called to the case? Or is the case such a losing case that The only thing to do is just delay, delay, delay. Maybe they'll have a few more years of peace before this hits them or something. It's just kicking the can down the road. These are the scum of the earth police officers. Absolute scum of the earth. Using your police powers to hurt the innocent and help the guilty is exactly the opposite. I don't even know how to be insulting enough because they're not police. That's not what the police are supposed to do anymore. Maybe that's what they were supposed to do when they were a legalized gang meant to round up people to be put back into slavery. But that's not what they do anymore, and it's no longer about bullying the innocent so you can have a position of power. It's no longer about us versus them. It's not the police versus the citizenry. It's it's about being citizens. It's about all of us living together peacefully. And this is again why I have this huge problem with the unpredictability of police officers. You should not have to wonder when you call 911. You should not have to wonder if you're making the right call. If they're going to send someone who prefers violence and prefers the gun over preferring nonviolent, but maybe more intellectual resolutions. Yes, I'm saying that police officers who pull their gun too fast are stupid, are literally super freaking willful stupid. That I don't have stronger words for it. The 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 fact that the courts have supported hiring the dumbest police officers instead of the smartest police officers, which is a real thing in real cases, not just one, but an actual nationwide policy. It blows my mind. You can be too smart to be a police officer, and it is not discrimination to refuse to hire smart police officers. That is a real thing. When a district court denies qualified immunity on a motion to dismiss, we may immediately review. So, interlocutory. Qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. So either these officers are plainly incompetent or they knowingly violated the law. Government officials are entitled to immunity from 1983 suits for damages arising from their duties unless the plaintiff can show that the officer violated a statutory or constitutional right that was clearly established at the time. The officer's basic contention here is that even if they violated his rights, they are shielded from liability by the fact that an independent intermediary, the magistrate, the DA who approved their application for an arrest warrant, blessed their unconstitutional conduct. Our review here is de novo or brand new, so the judge isn't going to defer to the lower court. First, we explain the independent intermediary doctrine and the Franks exception to it, Franks v. Delaware, a 1978 case, Supreme Court case, 438 U.S. 154. Then we apply that doctrine to Few and Garcia's reckless or intentional misstatements and omissions in the warrant documents. Finally, we explain that the warrant affidavit could not have established probable cause without the offending misstatements and omissions. 1 second. Drink break. Drink break, and my lips are chapped. Yeah, I really want to know who this drunk driver is because they've redacted the drunk driver's name, and I'm wondering if the drunk driver is somebody that was important to them, somebody they know and like. Meanwhile, this guy was making a problem for them, so they got to make it look like it's him instead. Hughes claims officers Few and Garcia violated his Fourth Amendment rights by arresting and prosecuting him without probable cause because they included material misstatements and omissions in their warrant affidavit and materials. If established, such misstatements constitute a clearly established Fourth Amendment violation under Franks v. Delaware. As a baseline, the constitutional claim of false arrest requires a showing of no probable cause. Similarly, the gravamen of a Fourth Amendment claim for malicious. Yeah, we just said that. Probable cause, in turn, requires a probability or substantial chance of criminal activity, not an actual showing of such activity. Both violations, therefore, turn on whether a reasonable officer would believe the suspect had committed a crime. The independent intermediary doctrine ensures that officers can make reasonable probable cause mistakes. A warrant secured from a judicial officer typically insulates law enforcement personnel who rely on it from liability for unlawful arrest, even in the absence of probable cause. The shield applies because if facts supporting, excuse me, this shield applies because if facts supporting an arrest are placed before an independent intermediary such as a magistrate or grand jury, the intermediary's decision breaks the chain of causation for the Fourth Amendment violation. But the independent intermediary doctrine has an important exception. It is if it is obvious that no reasonably competent officer would have concluded that a warrant should issue, a neutral magistrate's signature will not protect the offending officers. Under the Franks v. Delaware case or doctrine, it is equally obvious that no reasonably competent officer would lie or make material omissions in a warrant application. Franks holds that an officer cannot avoid liability where a warrant affidavit 1. Contains false statements or material omissions, 2. Made with at least reckless disregard for the truth, so that's knowing or should have known, and 3. That were necessary to the finding of probable cause, so material part of the finding of probable cause, not just lied about something not important. An officer's decision to submit an affidavit barred by Franks violates the Fourth Amendment because the requirement that a warrant not issue but upon probable cause supported by an oath or affirmation would be reduced to a nullity if a police officer was able to use deliberately falsified allegations to demonstrate probable cause and, having misled the magistrate, was then able to remain confident that the ploy was worthwhile. So if a plaintiff makes the tripartite Franks showing, then any arrest or prosecution lacked probable cause, the defendant officers are not entitled to the protection of the independent intermediary doctrine, and the misstatements or omissions suffice to establish a Fourth Amendment violation. Two additional wrinkles to the Franks doctrine bear emphasis. First, Franks' liability is not limited to the person who prepared or signed the warrant affidavit. Liability can attach to any person directing the inclusion of false information in the affidavit, or any person who supplied false information for the purpose of compiling a warrant affidavit. So long as an officer prepared information for the purpose of inclusion in a warrant affidavit, he can be liable without preparing the affidavit. Second, Franks requires courts to conduct a corrected affidavit analysis. Courts must consider whether the warrant affidavit would support probable cause if the misstatements and material omissions were eliminated. At the motion to dismiss stage, plaintiffs need only point out specifically the portion of the warrant affidavit that is claimed to be false, accompanied by a statement of supporting reasons. By pleading such facts, plaintiffs meet their burden of alleging a Franks violation sufficient to withstand the test of Iqbal and Twombly. That says a lot right there. By successfully alleging a Franks violation, you meet your jurisdictional requirements. That there's been enough minimum contact, and you have jurisdiction, and you can sue. You have standing. You have standing and jurisdiction. But if they press the litigation, they must offer tangible proof to overcome the presumption of validity with respect to the affidavit supporting the warrant. So you overcome it now, but you still need to supply proof later. Thus, specific examples of misstatements and omissions, combined with inferential explanation as to their materiality, can carry a complaint across the 12b6 line. Another really big sentence. Specific examples in a complaint, Specific examples of misstatements and omissions combined with the inference, the explanation, inferring how those misstatements were used, carries the complaint across the goal line, and you win a 12b6, or rather, the plaintiff wins the 12b6 motion, and the case is not dismissed. In sum, an officer who recklessly or intentionally contributed misleading statements or omissions to a warrant affidavit violates the arrestee's constitutional rights. That violation has been clearly established since Franks, and what would we say that was? 1980. Darn it. Franks. Where is Franks? Franks v. Delaware. Up here. I just saw it. I can search for it if I have to. We're going to search for it. Franks. Nope. Don't type French. Your name is French. 1978. It was right there on the page. All right. Where were we? Corrected affidavit. I think we can skip that. We next apply the Franks doctrine to this case. The officer's probable cause case hinges on the drunk driver's allegation that Hughes said, in effect, "I'm a police officer." So we consider each officer's efforts to convince the magistrate that Hughes in fact said that. First, Officer Few. Hughes alleged Few contributed false statements to the incident report, knowing that report would be used in the warrant affidavit. Hughes also alleged Few knew Officer Garcia had omitted critical information in the two documents and failed to correct them. Under either theory, Hughes presented enough facts to support a Fourth Amendment claim against Few. First and foremost, because remember, we're on a motion to dismiss here. We don't have to prove the case. This is not proving the case. This is whether they clear the line. First and foremost, Hughes pleaded a direct Franks violation, pled in the thing, based on Few's contribution to the incident report. As discussed above, Few may be liable for a Franks violation if he produced information containing false statements or material omissions made with at least reckless disregard for the truth, and if he knew that information would be used in a warrant affidavit. So Hughes gets to try to prove that later. Maybe he can prove it already, but he gets to prove it later. This is just, did he plead it? Just did he plead it properly? Here, Few submitted the incident report entitled Impersonating an Officer. Titled Impersonating an Officer. That report omitted critical pieces of information from Hughes's statement while including statements from the drunk driver that the officer's own lawyer called crazy. For example, Hughes alleges he told Few about the drunk driver's erratic driving, that the driver's truck hit the median before coming to a stop on the side of the interstate, and that the driver repeatedly tried to walk onto the interstate in the way of oncoming traffic. But according to the complaint, the incident report noted only that Hughes told his Uber passengers to get a new ride, detained the drunk driver, and had handcuffs because he was a police officer at one time. Meanwhile, the incident report relayed an entire narrative from Officer Garcia's conversation with a drunk driver, but that narrative was crazy in the words of the Houston Assistant City Attorney's word. Word. Among other things, the drunk driver referred to Hughes as Jesse, suggested the drunk driver and Jesse were drinking at a flea market, or maybe a bar at 2 a.m., implied Hughes and the drunk driver had a prior relationship, and said Hughes was driving the drunk driver's white Sierra. But Hughes's name is not Jesse. No flea markets are open in Houston and serving beer at 2 a.m. Hughes did not know the drunk driver, and Hughes's black Jeep was also at the scene when the officers arrived. The incident report noted none of these obvious, crazy inconsistencies. Few had access, this is Officer Few, had access to ample evidence suggesting both that Hughes' statement was reliable and that the drunk driver's statement was not reliable. For example, Hughes sent the officers screenshots of his last Uber trip corroborating his story, but the report misstated the information in the screenshots, suggesting the displayed end point of the ride should have matched Hughes's actual stopping point, when in reality it only reflected the requested destination. Moreover, few presumably had access to Hughes's recorded 911 calls with the play-by-play description of the White Sierra's actions and the Uber passengers' voices. Again, few omitted any such discussion. Finally, and most importantly, the inconsistencies or falsehoods in the drunk driver's story should have decreased or eliminated its relative weight. But Few's report contained none of these facts. That evinces, at a bare minimum, that Few recklessly disregarded the truth. And there can be little doubt Few submitted the incident report for the purpose of its being included in the warrant application. Few's deep involvement with the case raises a plausible inference that he knew the incident report would be used to prosecute Hughes. Few conducted Hughes's interview. He submitted the incident report labeled impersonating an officer, indicating the focus of the investigation had already shifted to Hughes. He went with Garcia 2 days later and arrested Hughes. That Few completed the incident report while Garcia completed the warrant affidavit does not absolve Few of liability, given these strong indications that he knew exactly what purpose the incident report would serve. Hughes's allegations suffice to raise a plausible inference that Hughes's allegations suffice to raise a plausible inference that Few knew his reckless omissions and misstatements would be used in the warrant affidavit, and that is all he must show. Remember, motion to dismiss just needs to be plausible, it needs to be properly pled. Second, Hughes established a plausible claim against Few as a bystander. Bystander liability attaches when an officer knows that a fellow officer is violating an individual's constitutional rights, has a reasonable opportunity to prevent the harm, and chooses not to act. Here, Few allegedly knew the information Garcia contributed to the incident report and then to the warrant affidavit contained material misstatements and omissions that did not accurately reflect the evidence from their investigation. Few had access to substantial evidence contradicting the drunk driver's narrative and Garcia's recitation of the facts. Even if Few himself did not write the false statements, he submitted the report containing them. That raises a reasonable inference that he knew of the harm about to be perpetrated but submitted the report anyway. That is enough for bystander liability at this stage. Second, Officer Garcia. Hughes alleged the Standard Franks claim against Garcia. Garcia may be liable if he knowingly or with reckless disregard for the truth included the false statements or material omissions in the warrant affidavit. Garcia prepared and submitted the warrant affidavit that directly led to Hughes's arrest. That affidavit contained numerous false statements and material omissions. Most importantly, Garcia materially altered the drunk driver's statement from the incident report. That version, the version of the drunk driver's statement in the warrant affidavit, patched many of the obvious holes in the incident report. For example, it omitted any reference to Jesse. It also resolved the inconsistency as to whether the drunk driver was at a flea market or a bar, only mentioning the flea market, though it again did not address which flea markets in Houston were open and serving beer at 2 a.m. And the new version of the story explained that Hughes's Jeep arrived at the side of the highway because 2 female friends drove the Jeep. By altering these details, Garcia's affidavit manufactured a more credible narrative. They made up a story. Garcia's affidavit also omitted external evidence undermining the drunk driver's credibility or supporting Hughes's. For example, the affidavit failed to mention the HGN test, or that Garcia got 6 out of 6 clues, which is a fail, indicating intoxication. It excluded reference to the Uber receipts showing Hughes picked up his passengers at approximately 2:30 a.m. and so could not have been out drinking with the drunk driver at a flea market. Then, despite admitting that he listened to the recording of Hughes's 911 call, Garcia omitted the stated purpose of the call, Hughes's description of his Jeep and the Sierra, Hughes's real-time description of the drunk driver's actions, Hughes's explanation for restraining the driver, and his repeated exclamations to the driver to stay and get back in the car. Finally, Garcia did not mention the third-party 911 call that corroborated Hughes' statement. The affidavit also added false details beyond those in the drunk driver's narrative. Most significantly, Garcia's affidavit claimed an Officer A. Walters was also at the scene. According to Garcia, Walters reported that Hughes handed documents to Walters and that he said he retrieved. Oh, that he said. According to Garcia, Walters reported that Hughes handed documents to Walters that he said he retrieved from the drunk driver's vehicle, but Officer Walters' name appears nowhere else in the record, including the incident report, and Hughes's statement made no mention of any other officer other than Few and Garcia arriving at the scene. At oral argument, counsel for the officers was unable to offer any information or justification for Officer A. Walters suddenly appearing in Garcia's report. All told, Garcia's affidavit made at least 8 material misstatements or omissions. Material, not little ones. These are material. These are not little white lies or whatever you want to call them. These are material misstatements. This is like fraud. This is like saying something that's untrue to get something you're not entitled to. That's like doing it 8 times. This is like 8 counts of lying to get something you're not entitled to. And instead of getting money, you're getting somebody you don't like. This not a police officer, former police officer who stepped on your territory, you're getting him thrown in jail. Any reasonable officer would have known, based on the evidence available, that the affidavit contained these errors. Hughes therefore sufficiently pled that Garcia violated his clearly established Fourth Amendment rights by producing and submitting the affidavit. Finally, the corrected affidavit analysis. Officers are liable for their false statements only if those statements were necessary to the finding of probable cause. We consider whether probable cause existed to arrest Hughes for the felony of impersonating an officer, even without the erroneous statements and omissions in the affidavit. The answer is easily no. Once the officer's misstatements and omissions are corrected, there is no basis to find probable cause that Hughes committed a felony. To the contrary, in the absence of the officer's misstatements and omissions, Hughes effected a valid citizen's arrest under Texas law. State law provides a peace officer or any other person may, without a warrant, arrest an offender when the offense is committed in his presence or within his view, if the offense is one classed as a felony or an offense against the public peace. And Texas's highest court for criminal matters has held this authorizes a citizen's arrest of a DWI suspect. Consider the facts of Miles v. Texas, a Texas Criminal Appeals Court case from 2007. The citizen in that case was a tow truck driver who chased a fleeing DWI suspect from a crash scene at high rates of speed over a median, wrong way down a one-way street into heavy oncoming traffic. The Texas court understood the issue as whether the citizen effectuated that arrest in a reasonable manner, a manner that a peace officer standing in a citizen's shoes could have legally done under the Fourth Amendment, and without significantly increasing the risk of danger, without significantly increasing the risk of danger and harm to the public welfare. Because the police officer could have driven the way a citizen tow truck driver did, that was sufficient to show the citizen effectuated a reasonable and lawful arrest. So too here. The Miles case allowed Hughes to arrest the drunk driver in a manner that a peace officer standing in a citizen's shoes could have legally done under the Fourth Amendment. Hughes retrieved the drunk driver's license and keys and used handcuffs to restrain him, all of which a police officer could have done. So there can be no doubt under the allegations in Hughes's complaint that his citizen's arrest was plainly lawful. Messes. Other evidence confirmed that the lawfulness of Hughes's actions and further eliminated any whiff of probable cause against him. His 2 911 recordings revealed the urgency of the situation and the need for a citizen's arrest when the drunk driver repeatedly endangered himself and others. There was also the unmentioned 911 call from another concerned citizen corroborating Hughes's story, and when the officers arrived, the driver was visibly intoxicated, failing the HGN test on 6 out of 6 factors. Thus, no one could reasonably conclude Hughes was impersonating a police officer simply because he detained another citizen. Hughes's story confirmed what the evidence suggested. At every turn, Hughes repeated that he was a former police officer. He had been driving two passengers for Uber when he saw the GMC Sierra driving erratically. When the Sierra came to a stop after two collisions, he pulled up behind it. Concerned for the drunk driver's safety and the other drivers of the interstate, he used handcuffs, which he possessed because of his previous work as a police officer, to detain the drunk driver while he waited for help to arrive. According to Hughes's complaint, at no point did Hughes suggest to anyone that he was currently a police officer. The only evidence suggesting Hughes ever impersonated a law enforcement officer, thus the only evidence that could possibly have established probable cause, came from the drunk driver's statement. As discussed above, the drunk driver reportedly told officers Few and Garcia that Hughes had claimed to be a police officer. But even the officers' counsel admitted that this assertion came in the midst of the drunk driver's crazy statements. Quote, crazy statements. Given the vast inconsistencies, indeed impossibilities, reflected in both versions of the drunk driver's statement, the driver's obvious intoxication, and the evidence supporting Hughes's account, no reasonable officer could have suspected Hughes committed a felony. Therefore, a corrected warrant affidavit could not have established probable cause to arrest and prosecute Hughes. It is unclear which part of this case is more amazing, says the judge, that officers refused to charge a severely intoxicated driver and instead brought felony charges against the Good Samaritan who intervened to protect Houstonians, or two, that the city of Houston continues to defend its officers' conduct. Either way, the officer's qualified immunity is denied, and the district court's decision is affirmed. So that will go back down to the district court for further hearing. This is one of those cases that needs a giant flashlight, needs a giant spotlight. These officers, this is criminal level corruption to make these false statements in order to get a fellow officer, former officer arrested, to let a suspect go so that you can focus on getting this other good guy arrested. These officers are not officers. These people are corrupt and they should not be officers, and they bring a bad name to the profession. Just like lawyers are supposed to get other lawyers out of the profession when they're bad. We would expect doctors to tell on other doctors, and maybe they don't do that often enough. I don't know. There has to be policing of police, and it can't be the police get to police themselves and declare themselves crime free. That's statistically impossible. So there needs to be an independent police auditing agency, just like there are independent agencies that audit other professions. It took, 4 years and an extra semester for me to get my law license, and that was after a bachelor's was required, and I also got a master's degree. But so a bachelor's and then 3 required years of day law school is 7 years of training to be able to talk to a judge as a lawyer, to represent a client. But police officers need 6 months. That's not right. So the thing that really stood out to me in this case, where was it here? Besides the false statements and the arresting of the good guy, I liked the way the judge brought up the purpose of qualified immunity. Let me see. All but the plainly incompetent or the knowingly violating get qualified immunity. So that means, according to this judge, according to these judges, the district court judge as well, and the Fifth Circuit Court of Appeals, these officers are either plainly incompetent, which I'm saying no. I think it's more like they knowingly violated the law, which I would call corruption. So yeah, let me know what you think of that in the comments below. Makes me mad as hell. Officers are officers. I'm an officer of the law, the courts, attorney and counselor at law. That's an officer of the court. I would be an officer of the judicial branch. They're an officer of the executive branch. And to me, they should be held to my standard. They should be held to the same standard as lawyers. I have to be generally trained and pass the bar. Okay, I represent clients and stuff. There can be a different program to train police officers, but there's no way. There's no way that police officers are ready to enforce the law after 6 months. What they're ready for after 6 months is to protect themselves from the militant citizenry that needs constant reminder through violence and oppression, constant reminder that the police are the ones in power here and get out of our way. Don't get in our way. So yeah, I apologize to all the people who want to be good police officers and then find the system is hopelessly corrupted and they can't make the change and the difference that they want to make in the world. I don't know how you make that change unless we all decide to do it together at once through legislation or something. That's a philosophical discussion that we can have in the comments. Yes, to be fair, this is a very good point. Thank you very much. To be fair, we also have our Leibowitzes. So, yes, we have a very plainly incompetent or knowingly violating lawyer named Richard P. Leibowitz, who is now no longer a lawyer, thank goodness. But yeah, that was maybe he didn't um, maybe he didn't lock somebody up in jail unjustly or charge them with a crime, but he definitely took people's money, made them worry. I'm aware of people in general who have committed suicide because of the stress and the unknown of being sued by one of these copyright trolls. So it's on some levels it can be just as bad to be a bad lawyer copyright troll as a corrupt police officer. Um, Let me know what you think in the comments below. Good story. Bad fact. I mean, terrible situation for Mr. Hughes, but good story. Good story. And I hope I hope this is like the Streisand effect for this one. I don't know. I don't I don't want to astroturf. I'm not an astroturfer. I just think this one should get a lot of attention. It certainly landed on my front doorstep a number of times. Anyway, love you all. Let me know what you think in the comments below. Bye. Yeah, how dare you be a cop on our turf? Yeah, I get that. There's another one in Pennsylvania who were dealing with sexual assault cases. Why would it matter that he possessed handcuffs? Oh, that could be illegal in Texas. It could be. I doubt it. I think probably you're allowed to own handcuffs, and it's just illegal to restrain people when they're not committing a felony or otherwise fall within the citizen's arrest statute. You might have heard me say officer officered instead of officer offered. I might have to go back and re-record that to make sure I get that one right. That's a bit too distracting. Uh, Another one. Okay, so the bar has not got him yet, but it came up in oral argument. Okay. Yeah, it used to be that lawyers had a duty to report other lawyers, and then I guess that went away. It sounds like a First Amendment association thing. I don't know. I'm not. I can police other lawyers to a point. I can still make a complaint against other lawyers, but to have like a duty to do it, or else I get in trouble. It's weird. But yeah, that's the same similar thing. Like if you see a an officer, committing a crime or omitting something in a report or whatever, you have to do something about it. And if I see another lawyer doing something illegal, I should also do something about it. Um, a lawyer did report this one. Good. Okay. Well, if you want to put a link in the, um, I guess, the submissions channel, go ahead. I'd love to read it. This is already there. Anyway, that's what I have for you today. My my people, I think, are going to go play some Abiotic Factor, and I will see you in the videos that drop. Where did the women come from? Yes, exactly. I don't know. This guy just made up that he had these two women. I guess maybe the drunk driver saw the people in the Uber, which might have been two women. I don't know. Anyway, love you all. I'll see you in the videos that drop. Have a good Sunday and a good week.